need to disclose because you don't need something, you're better off not doing any disclosure. Unless there's like no way to hide it because it's like a resume issue and they're reading your resume or something. But is that, you know, I don't know if that's applicable to everyone.
I'd probably have to disclose it because it explains like certain gaps in my employment.
I'm actually in the same boat, but like if I wasn't in that boat, this is the approach I would take.
So I had a question about disclosing during an interview. Because of my learning disability, actually reading and getting stuff down takes a good amount of time, and I don't want to wait to disclose because it'll look like I'm not working up to the standard that they want me to work up to. And I have disclosed in interviews before to people. It's been pretty uncomfortable. Is there any advice you could give about something like that? Because otherwise, I can't hide it, or else I'll look lazy. So.
I might suggest, I think you're right in that you don't want to wait too long, especially if you need an accommodation or something like that, or to help you get things done in the way that they want them done or whatever, or some extra time, etc. But I don't think it's necessary to disclose on an interview, maybe just soon after hire, say, well, I am going to need these accommodations. Because you're not required to disclose during an interview, and two, if you do, I found, and people I talked to, it's much more difficult to prove discrimination at the interview period because there's so many things that go into a decision, and so it's very hard to show that disclosure of disability was the reason that you were not hired. So while I would definitely suggest disclosing early on in the job if you know you're going to need an accommodation and not wait until you've had bad performance evaluations or anything like that. I might wait till after you were hired and then discuss. I don't know.
That's what I did at DRA. I mean, they knew I used a wheelchair clearly, but after they gave me an offer to be a summer, that's what I did, and it was no big deal. I mean, with that, my disability was clearly the asset. And I'll also say, when you do explain your disability and disclose, I think packaging is so key, and you all are smart, you're in law school, you know how to do it. I mean, just present it as like, this is the issue, this is how I deal with it, and you don't know the difference, accommodations, level the playing field, bam, work product.
Yeah, focus on strengths, because, best foot forward, yes, I have. Perhaps easier said than done, but.
And I would jump in, and this is something that I tell everybody about when I talk about accommodations because I think it's really cool. But there's an organization called the Job Accommodations Network. They have a website, you guys may be familiar with it already, but they have, it's a number you can call to ask about what sort of accommodations might help me or might help my employee. But they also have little booklets on almost not every disability, but many disabilities that explain what the disability is, what the limitations can be, and what accommodations can assist with those limitations. So if you're, have an employer that you're nervous about talking to, or you think might not be really knowledgeable about disability issues, it may be helpful for you to review that booklet or even to go in with it in hand. So that's another tool that you can use if you're struggling a little bit with disclosure and asking for accommodation.
And what's nice about law school, and we'll get to all of your questions, is that you have the chance to sort of, it's not exactly speed date, but you get to sort of try out different groups and internships or summers. And so, some group some employer might say, well, I don't want to hire as a lawyer a person with a disability, that's too scary. In their, they wouldn't say that, but in their head. And then, but if they have someone for an internship and that they were great and they help them out, then all of a sudden the disability just recedes.
Was your question, though, I was trying to get around it, was your question about you thought maybe in the evaluation, when you're in the pool of candidates, you may not look like the strongest candidate because of your disability, and that's why you wanted to disclose? Was there something about that to your question as well?
No, I felt like this is such a part of the way that I work. I'm very good auditorily, orally. It takes me a while with the writing and the reading. And I feel like, in a way, not disclosing that is not putting out something of myself that's very it's very important towards the way that I work. So, I don't know, for me, it was just, it's been hard trying to figure out when to put that information forward in what format.
And it can help find the match, which I learned too sometimes, too, that's the trade-off.
Yeah, and some of that there's some work environments where you can shape that in more ways than others. Because there may be other people who don't have learning disabilities who learn in other ways as well, too, and may be more receptive to that. And so maybe more of a group issue than a disability issue on some fronts. And then you add on the accommodations. So sort of a way to explain it. I also found that with so many students with LD, like that's showing that later on in the stage when we're talking about disclosing, like showing some of the technology that you may use or something like that. Now there are other people in our office who want to use some of that technology at the law school, who are sort of aging into it or have injured into it or just feel like this might be more work better for them because they're realizing that they learn in a different way, even though it might not be a diagnosed disability. So you have that as a resource to kind of share. So you become their resource. Because they may become more efficient or feel more comfortable in learning too. So it's kind of cool, but it's something that you can offer later on.
We've had two.
At what point, it's kind of going off what she said, at what point is it kind of disingenuous to the client, as a familiar with PR professional, to be billing, say you have time and a half? At what point does it become disingenuous to your client to say, look, we have somebody working on your case, but it takes twice as long to do it, so he's billing twice as much to you?
Well, that may or may not be how the hours turn out for a person. Depending on the accommodations and the task, if you're managing, if you have a good manager, the person with and without disability should be doing things at an appropriate pace. But certainly, assuming all the facts in your hypothetical, I think, probably there would be billing discretion.
For the employer?
Yeah.
And I have a learning disability, so, I haven't really sent my tasks or something that I would like to apply at work, but, I feel, honestly, a little bit uncomfortable billing for something that maybe I think should be, wouldn't take another associate long.
But you may not, I'm just saying, I was a little bit challenging the assumptions of your question because I think that as people with disabilities are in their jobs, there's a good match, their accommodations, the hours that you spend should be, pretty close, I would think.
Well,
To anyone, to your peers.
Well, I would say, just kind of thinking about this structurally, is sometimes, so it's different in law school than in practice. And it's right about the match. So might be some environments that aren't as good of a match. But there's a lot of, this may change, the economy is changing. But you won't be doing all of the tasks that you would do in law school. Like, it's not appropriate to bill an associate or bill for an associate a partner or skills for some things that should be going to the administrative assistant or the paralegal. So we're going to try to use what you've gone to law school for your higher level of skills, right? So there's some things that may slow you down. Now, I don't know what the learning disability particularly is, but there may be some things that were sort of off-sourced to someone else as part of the accommodation process. It may speed you up a little bit. But the issue is, in terms of billing, like, I have an example for you. It's not a comforting one, but, and it's probably gonna not, okay, so I have, from my study, I have somebody who would take twice as long, and she can't bill her clients for that. That's the answer. This is in solo practice. In a firm environment, associates are slower than they need to be. All associates are slower. You take forever to do things. Research assistants for law professors, oh my gosh, they take forever, like 10 hours to do something it would take us an hour to do. That's not a disability issue so much at that point. It may take you even longer than that in the normal thing of things. But here's one person I know is a solo practitioner in Atlanta, and she is a blind attorney, and she's an older blind attorney. She hasn't used technology as much, but she has to hire a lot of people to assist her. She has a secretary, she has a reader, she has a driver. Those are all added expenses to her solo practice. She can't bill her clients for that. Reality is that since she's a solo practitioner, she ends up making a lot less money than another solo practitioner. It's not comforting in that sense, but she's slower for a different reason. She's more expensive for a different reason, but you can't. That wouldn't be a good business model, right? If you were billing twice as much. And the firm, a lot of firms eat